You're watching Book TV, only on C-SPAN 2, created by the cable television industry. This book is written by law professor David Friedman, son of economist Milton Friedman. Recently, he sat down with Book TV to talk about his new work, Law's Order, what economics has to do with the law and why it matters. It's 30 minutes.
David Friedman is the professor of law and economics at the University of Santa Clara. He's the author of Law's Order, what economics has to do with law and why it matters. Dr. Friedman, what does economics have to do with law?
Legal rules exist in large part to change what people do. If you think about a traffic ticket, a speeding ticket, you could think of a speeding ticket as a rather odd way of collecting taxes, of making the state of California richer and me poorer. But the state of California really has better ways of getting money from my pocket to theirs. And the reason for a speeding ticket is to make people drive more slowly. And you can expand that way of thinking about it and look at the whole legal system as rules designed to affect how people act, in particular to make sure that when I take actions that impose costs on you, I take account of those costs in deciding what to do. And economics deals with understanding how rational people respond to incentives. So if you want to think about a legal system as a set of incentives, as a set of rules designed to modify people's behavior, the natural way to do it is to apply economics and to try to figure out what the effect of a particular legal rule will be. One example I like using, I have in the book, is to imagine that you're in a legal system where the highest punishment you give is life imprisonment. And somebody says, look, armed robbery is a terrible thing. We ought to give life imprisonment for armed robbery. And a legal philosopher will say, is that just? A constitutional scholar will say, is that cruel and unusual punishment? An economist will say, do you really want armed robbers to routinely shoot their victims? Because after all, if the punishment for armed robbery and the punishment for armed robbery plus murder are the same, the additional punishment for the murder is 0, and dead men are very unlikely to identify you at a police lineup. So there's then a strong incentive for armed robbers to commit murder. So that would be one example where the economic way of thinking, of saying not what's the rule designed to do, but what effect will it actually have on behavior, is very useful.
So why would one take an economic view of law? To change it or just to understand it differently?
I think both. I think the economic approach can be used both as a way of trying to make sense of law and as a way of deciding what you think the law ought to be. That one way of doing is to say, well, we suspect, though we're not sure, that the legal rules exist to create certain objectives, to make people behave in certain ways. And where you have complicated legal rules, those of your listeners who are law students or lawyers will know that you can spend many, many hours just understanding contract law or just understanding procedure. Where you have complicated rules, thinking of the system of rules as a tool with a known purpose makes it easier to make sense of it, easier to say that's why this rule is this, that's why that rule is that. But you also sometimes say, well, but this one doesn't make sense, this one doesn't achieve the purpose. And then that becomes an argument for why you might want to change the rule.
What are the non-economic ways of looking at law?
Well, you should probably talk to a non-economist legal scholar to get a good answer to that. But certainly one is thinking in terms of justice. And I think the basic problem is that we don't have any very satisfactory theory of what justice is, at least none that I've seen.
Isn't it doing the right thing?
But then what's the right thing? I've actually just been rereading a recent book by Judge Posner, who's been a very active writer in economic analysis of law and in many other things. And he spends the first chapter of the book on a demolition job of academic moral philosophy, where he's arguing that it's essentially completely useless for any human purpose. And he's pretty convincing. So we certainly have intuitions of justice. And one of the things that I find intriguing is the degree to which, when you figure out what economically efficient law is, it very often fits our intuitions of justice. And I think you can sometimes refine the intuitions of justice by looking at the consequences of rules. But I don't think we have a theory of justice that's solid enough to answer any real questions that real human beings disagree about.
In the book, you go so far as to say that what we call the principles of justice may actually be rules of thumb for producing an efficient outcome, rules we have somehow internalized.
Yes, note the word may at the beginning of that.
Yeah.
What I'm saying is that we make the following interesting observation when you do economic analysis of law, and that is that there is a good deal of similarity between the legal rules that economic theory says would be economically efficient, the legal rules we actually observe around us, and the legal rules people think are just. They aren't identical, but there's a lot more than random relation. And that's then a puzzle, why these things are similar. And one possible solution to the puzzle, I don't know if it's the right solution or not, is to say that justice, as it were, is just a mistake, that what's really going on is that we have internalized efficient rules, maybe through norms, that there are, in fact, better arguments for suggesting that norms will be efficient than that laws will be. And presumably, a lot of our ideas of justice are related to the norms that we've grown up, learning as good behavior. So that may be part of the answer. But the word may is quite deliberate because I don't really have a good explanation. I only have some guesses.
Are you a lawyer?
No.
Are you an economist?
Yes.
How can a non-lawyer be a professor of law?
By persuading a law school to hire him as a professor of law. Fortunately, our society is not yet so credential-ridden that it is illegal to hire people for jobs for which they do not have degrees. I'm an economist, and I've taught in both law schools and economics departments at a number of quite good universities. I have never taken a course for credit in either the field of law or the field of economics. However, I've published quite a lot of articles in both economics and law, and at this point I've published, I guess, two or three books in economics and one book in law.
And what courses do you teach in law school?
Currently, the two courses I'm teaching are a course in the economic analysis of law, which I use my new book for. And my new book was really written as a result of teaching that course, and a seminar that I invented, which is called Legal Issues of the 21st Century, which is a great deal of fun. Santa Clara University is sitting in the middle of Silicon Valley, which is a very intellectually active place where people are inventing all sorts of wonderful and scary new things. And so we have a seminar where each week we take one technology which I'm willing to argue, at least for a week, is going to revolutionize the world. And we then discuss the technology and then discuss, if it happens, how will the legal system adjust? What are the problems raised for the legal system in that world? So that to take one issue which should be near and dear to C-SPAN's heart, we have a discussion of the consequences of computer networking and encryption, in which I am willing to argue that we will have a world in which copyright in digital intellectual property is simply unenforceable, and people who make their living out of producing intellectual property in digital form will have to find indirect ways of being paid for doing that, because simply charging royalties for copyright will no longer be practical. But that's one out of about 10 or 12 topics we talk about: human reproductive technology and nanotechnology and all sorts of other things.
Sounds like another book.
Yes, but I have to teach the course for another couple of years before I have enough material for that book.
In this book, you actually do address intellectual property in a number of areas of law with an economic take on it. Well, why don't we go straight to intellectual property, where you make the case against intellectual property law, I think. What is intellectual property, first of all?
Sure. Intellectual property, the major forms in our legal system are copyright and patent. And that gives the creator of a work or an idea the right to control whether other people make copies of the work or use the idea. And I think it's too strong to say I make the case against it. What I do in the book is spend a chapter on property in general, in which the one central question is why some things are property and some things aren't. And to the non-economist, it sort of seems as though nothing should be property, that after all, if I want to use this cup. Why shouldn't I be free to use it, whether or not it belongs to you? Isn't it just sort of silly and selfish and wasteful? And then you learn some economics and you realize, no, that copyright, that property is a wonderful set of institutions for making sure that useful goods get produced, that the goods go to those who want them most, and so forth. And then the next puzzle for the economist is, why isn't everything property? And you start saying, well, let's suppose the English language were property. The first inventor of any word would own it. And before you used any word in speech, you would first have to locate the first inventor and pay him a license fee for permission to use the word. That would be a very quiet world, because the transaction costs of licensing all those words would be much, much higher than one would wish to pay. And that suggests that a general point that property is useful in many contexts, but there are other contexts where it isn't. And I spend some time going beyond that sort of trivial statement to try to explain what the advantages and disadvantages of treating things as property are. Then the next chapter takes intellectual property and tries to apply those ideas. And I would say the central argument of that is to show why the difference between copyright law and patent law makes sense, because they're very different legal systems. That I suspect that the words we spoke over the last 5 minutes are by now copyright.
Yes.
By C-SPAN.
That's correct.
Copyright is essentially a system where as soon as you create a copyrightable work, boom, it's invisibly copyrighted.
And this is being videotaped, so it's reduced to a tangible form of reproduction.
That's right. Whereas patent, you think up an idea, you then go through a very elaborate application process which takes years. You have to persuade the patent examiners of a variety of things and so forth before you get your patent. And I argue in the book that this distinction is a sensible distinction, that the kinds of things copyright protects are the kinds of things for which property rules make a lot of sense. In particular, the problem of my copyrighting something and thus keeping you from doing it yourself is essentially zero, because nobody else would write my book anyway. Whereas with patents, it's quite likely someone would invent my idea later independently. Therefore, when I invent the idea and patent it, I am restricting the options of lots of other people, and it should be more difficult to do that than to simply create something out of nothing, as it were, which is what a book is doing. Now, again, I spend a chapter on this, so this is a very brief summary. So I would say that's the main argument, and I then discuss why there are arguments against intellectual property, arguments for intellectual property. And of course, one of the things determining whether property makes sense in anything is how easy or hard it is to enforce. And that comes to my point that my reading of the technological changes is that certain kinds of intellectual property are going to become prohibitively difficult to enforce.
Well, why don't you comment on the Napster issue right now? Because the music belongs to the people who write it and publish it, yet it's being distributed free on the internet.
But the interesting point, I think, Napster, as I understand it, and I haven't followed that case in detail, is a sufficiently centralized system so that there's somebody to sue. However, the right way of doing it, not from a moral standpoint, but if you just ask if you want to achieve what Napster has achieved and not end up getting sued, is to set up a system sufficiently decentralized so that there is no central organization involved, so that somebody produces software and distributes it, lots of people have it on their machines, the software is well designed, it's designed so that you can find a piece of music but can't identify who the person is on whose machine it is, so that the owner of the copyright can't identify him in order to sue him. And my reading of the technology is that, except in the very short term, we're going to find that those mechanisms are going to develop, and that there are going to be ways that people can share music without it being practical to use the law against them. Now, this is a very old problem, of course. If you think about computer programs, the software industry has been living for, I suppose, 20 years or so, with a world where all of their users could cheaply copy the things they were expensively selling, and has nonetheless found ways so that Microsoft has not gone bankrupt yet, nor have a variety of other companies. So I think the real lesson is going to be, over the longer term, not that you use the law to protect your copyright, but that you find other ways of getting rewarded for your music. It's an interesting fact that 100 years ago, well, more than 100 years ago, prominent writers such as Mark Twain made a lot of their income by giving lectures. So that what they were doing was making themselves famous public figures by writing books and then cashing in on that largely, not entirely, by lecture fees. And that's sort of one example out of the multitude of ways in which people who create intellectual property can find indirect ways of being rewarded for doing that.
I want to ask you about the men to whom you've dedicated the book. It says it's dedicated with respect and affection to Aaron Director and Ronald Coase.
Yes.
Who are they, and why did you dedicate your book to them?
Well, one reason, of course, is that they are both men who I know and like, but the more fundamental reason is that they are the two people who I think most responsible for the rise of the initial development of economic analysis of law. Aaron Director was the first editor of the Journal of Law and Economics, which was the first law and economics journal. He was a major influence on Posner and on quite a lot of other people. He's the interesting case of a very influential scholar who was influential almost entirely through other people. That is, he published very, very little, but he started ideas and he talked with people and he taught people and so forth, and he ran a journal that really began the field. Ronald Coase is an English economist who revolutionized economic thinking about the issue economists call externalities, which is how you deal with situations where my action imposes a cost on you, except that part of Coase's lesson was that that was really a misleading description. And in fact, there's a famous story, which I repeat here, which I think I got from George Stigler, which is that it used to be that everyone in economics knew the solution to the problem of externalities. And this was the solution due to a man called Pigou, which was, if I take actions that impose costs on you, tax me an amount equal to those costs.
Well, an example would help here.
Sure. Pollution is the standard example, but there are lots of others. My factory pollutes the area where your house is. That makes you worse off by what you would evaluate at $200 a year in smelly air once in a while. So the Pigouvian solution is to say the government should observe that I'm doing $200 worth of damage, charge me a $200 tax on behalf of you, maybe other taxes on behalf of other people. Now, since I'm now bearing the full cost of my action, I will only continue to pollute if stopping the pollution costs more than the damage done. Now, it might be done through a fine, it might be done through the tort system, you might sue me for the $200, but from the Pigouvian standpoint, either of those is a mechanism for giving me the right incentives. And this was all had been well understood for, I suppose, 20 or 30 years when Coase started working on the problem. And Coase argued that the standard analysis was wrong several times over. That to begin with, it isn't really right to say that I'm imposing a cost on you. Because after all, if you weren't living downwind from me, if the area downwind from me was being used for forest or for cattle who didn't mind my pollution or something, there'd be no cost. So that the right way of thinking about the problem is rather that you and I are jointly acting in a way which imposes the cost.
By living there, I'm part of the problem.
That's right. And that therefore, in general, when you're setting up your broad legal rules, you don't know which party you should be giving the incentive to solve the problem. There are some cases where the right solution is for the so-called victim to adjust and
to
sometimes
move.
Yeah, the standard example I give is suppose you decide to set up a recording studio in the middle of downtown Manhattan, and your recording studio has got very sensitive microphones, so that any noticeable noise within a quarter of a mile will prevent you from doing your recording. So first you set up your recording studio, then you sue everybody within a quarter of a mile of you, telling them you may not turn your television above low, you may not drive your car unless you've got all sorts of sound protection and so forth. That would seem crazy. And yet, formally, that's the Pigouvian solution. And what's wrong with that is that the efficient solution there is for me to put my sound recording studio someplace quiet, not for me to put it someplace noisy and shut up all the neighbors. And Coase, in fact, got to his arguments in part by looking at cases in English common law One of the cases he discusses is one where you've got a candy factory in London, which has been operating for, I don't know, 50 years. And it's got big mortars that pound stuff and must have made at least a little bit of noise and vibration. No problem. Until the physician buys the house next door. He builds an extension onto his house right adjacent to the wall of the candy factory, wants to use it as a consulting room, and finds it's too noisy to use and sues the candy factory. So that nicely raises the point that really it would have made more sense for the physician to build his consulting room on the other side of the house rather than shutting down the factory. So Coase argued first that Pigou didn't have the problem right, but second, that there was another set of solutions, which was bargaining between the two parties, where instead of saying the state will decide who should adjust, we just say the state says, the court system says, that the physician has the right to close down the candy factory. Next step is not the candy factory closes down. Next step is the candy factory goes to the physician and says, how much would it cost to move your consulting room to the other side of your house? I'll pay for it. So Coase's second step of the argument is to point out that as long as the parties affected can bargain, it's in their interest to find the efficient solution to the problem, whatever the initial legal rule. And then the third step is to see why that often doesn't happen, because in many contexts, private bargaining is prohibitively costly. So if my pollution is polluting not one house, but 1 million houses, now, if I have a right to pollute, it's not going to be practical for those 1 million people to get together and pay me not to pollute. So, essentially, it's, again, if you really want to understand it, read the book. But Coase showed that you had to think about these issues, which are really very central to law, in a very different way. And the story Stigler tells is that Coase came to the University of Chicago to give a talk on this subject. And he had dinner at the House of Air and Director with, I suppose, about a dozen economists present, of whom, if I remember correctly, I think 4 eventually got Nobel Prizes, much later than this. But they were very bright people. And at the beginning of the evening, the argument started, and it was Coase on one side and everybody else on the other side. By the end of the evening, it was unanimous on Coase's side. So that was sort of quite a startling example of simply ideas changing how people thought.
You've already mentioned Richard Posner. He's a federal judge. Who is he, and why is he most closely associated with this economic view of law?
Well, I guess I suppose there are 2 reasons. One of them is that he wrote what at least used to be the best book in the field. I hope I'm now going to replace him, but may or may not succeed. They're really rather different books. But he wrote a book called The Economic Analysis of Law, which I like to describe as a treatise masquerading as a textbook, in which he tried to sort of put together everything that was then understood, including a lot of his own ideas, and he's kept updating it since. So that's one reason. But more fundamentally, I guess there are 2 other things. One of them is that Posner introduced into the field a conjecture which has turned out to be very productive. And his conjecture was that the common law is economically efficient. By economically efficient, roughly speaking, we mean a set of rules that maximizes the size of the pie, that maximizes the degree to which everybody gets what he wants. And that's a gross oversimplification. I spend a chapter on that question, too. But Posner's idea was that somehow the part of the law that's made by judges, the common law, is not laws passed by Congress. Common law is law that arises from the decisions of past legal cases, which are then precedents in future legal cases. And his argument was that somehow that part of the law tended to be an economically efficient set of legal rules. I'm not sure he's right. I mean, I discussed that question at great length in the book. But it's clear that that conjecture was very productive as a way of thinking about the law, because it got people thinking about the question in many different areas of the law. What would be the efficient rules? Do the present rules make sense? And so forth. Posner himself did a lot of that work. He's been an enormously prolific scholar. But I think a lot of other people, myself included, as a result of his putting forth that conjecture, thought about different questions than we would have thought about. So that in that sense, I think more than anybody else since the very early people. Since COSM director, Posner has really been the person who's shaped the direction in which the field has developed.
What's the upshot of all of this economic theory of law? Has the law changed because Ronald Coase and Aaron Director and Judge Posner have done things differently?
Yeah, I think so. It's very hard to be sure because, of course, the law is a very complicated system, and if a change happens, you can explain it in many different ways. I suppose the most striking example in Coase's case is that, as you may know, radio frequencies, are now to some extent allocated by auction. Coase made that proposal, I suppose, somewhere in the late 50s, maybe early 60s, in his article on the Federal Communications Commission. At the time he made that proposal and many years after, it was obvious to anybody that it was an absolutely politically impossible idea that would never happen, just a crazy, scholar's suggestion. Now we're doing it. So there is some influence, and I think that a significant number of judges, to some extent, take into account the economic analysis. On the other hand, there are also very large political factors. A friend, an ex-student of mine, was involved as an economist with the Sentencing Commission. And the Sentencing Commission came out with a schedule of recommended sentences. And I gather they claimed that that was based on economic analysis. And my friend who was doing the economics was very unhappy with what they came out with. And I think the obvious implication was there were political pressures to get very severe sentences, and those political incentives were really what was determining what was happening. So I think the economic analysis has some effect, but I certainly don't think that Posner has converted the entire judiciary into revising the law as he and I might like to see it revised. And of course, I don't always agree with him about how it should be revised.
I want to ask you a question about the book itself.
Yes.
We're going to show the audience this page in the introduction, and you've got icons along the side of the page describing what each one is for. For example, here's I guess an icon of a book. It's a citation to a book or article, linked to a webbed book or article, a case, meaning a law case. Math, what does that mean?
What these icons are...
Well, in math in particular.
Means a mathematical explanation of some point in the book.
Okay, and then additional comments is further down. And then throughout the book, as you can see me flipping through it, you see these icons across the book. Now this substitutes for...
footnotes.
All right.
This is my system of virtual footnotes.
Is it a first?
I'm not sure. Steve Landsberg seems to have done something somewhat similar but not identical in one of his books. But
how does it work?
There is a web page associated with the book, which is available to everybody. It does not require any password. The web page has the entire book on it as page images, so that it's essentially like photographs of the pages. You can read them, although not nearly as easily as in the book. The icons on the page images are links. You click on one of those icons, and you now bring up some additional material, like a footnote. But it's got some very large advantages over conventional footnotes. For one thing, there's much more material there because I have no space constraint. Most of my published articles are already webbed. So any time the reference is to an article of mine, what you get is not merely the citation, but the whole article. You can read it on the web. If I put in a footnote which cites an article of mine, I know that not one reader in 300 is ever going to go to the trouble of finding a library that has the journal, looking up the article, and reading it. This way, anybody who's interested, just click, click, there's the whole article on his screen. Similarly, I can link to things other people have webbed. I have references to a couple of books, to Marshall's Principles and Adam Smith's Wealth of Nations. Both of those books are up on the web. So I can have a link to the whole book, and if someone is curious, he can keep reading other than the stuff I'm referring to. In a book like this, which is aimed at least in part at a popular audience rather than just a textbook audience, I would never dare to include any substantial amount of mathematics because most readers find that very uncomfortable. But some readers like mathematics. And so this way, here's a 3-page formal mathematical analysis of this problem for which I've given a verbal sketch in the text.
So how is the system working as far as you know?
That's very hard to answer because it's quite new. The book's came out, I don't know, 6 months ago or something. One thing I that did happen was I got a number of emails from people who didn't like it because they wanted to be able to read the footnotes when they weren't online. And so to respond to that, I created a file that's the full set of notes, except no links anymore, which you can download and print. And I think it was 60 pages or so, which suggests how much more I have in it than an ordinary set of footnotes. So that way, if you want the equivalent of ordinary notes, you download it either to your laptop and take it with you to the beach, or you print it out, and you now have the notes. You now can't link to my articles because they're up on the web, but you couldn't link to them if I didn't have virtual footnotes either.
Is there an economic incentive for your publisher to go along with this?
I think it's going to result in selling more books. You might think of the system as price discrimination in the sense that given that reading the text itself on the screen, although possible, isn't very easy because if you think about the resolution of a screen, it isn't nearly as high as a book page. I figure that anybody who is likely to read the book is not going to substitute for reading the book on the screen. On the other hand, a student in Turkey or India or some fairly low-income country who's interested in this subject is never going to pay the cost of the American book, but he is going to be willing to suffer through reading the book on the screen and thus spreading my ideas a little farther.
Oh, we're just about out of time. We ought to mention that you are the son of Milton Friedman, the economist. How has being in that position influenced your career, do you think?
Well, it was certainly one of the reasons I originally went into physics instead of economics, because I didn't want to spend my life answering questions about being my father's son. And it's one reason why, when I decided that I actually liked economics better and was better at it, I've gone into very different fields than my father. However, I should say that Aaron Director is my uncle. He is my mother's brother. But fortunately, the rest of the world outside of the field hasn't heard of him, so I can afford to be in his field, and I am.
Well, the book is Law's Order, What Economics Has to Do with Law and Why It Matters, by David D. Friedman, who's been our guest. Thank you very much.
Thank you very much.
David Friedman is a law professor at the University of Santa Clara. His new book, Law's Order, What Economics Has to Do with the Law and Why It Matters, is published by Princeton University Press. Mr. Friedman is the son of economist Milton Friedman.